So today we start the constitutional law. So what is the constitutional law? It is the common questions in Nepali, Samvidhani Kanon. So what is the constitutional law? Very simple. Constitutional law. Constitutional law is recognized as the branch of the public law of the state. That means it is also public law. Public law means government law. So, constitutional law, it is categorized as the public law because it is applied between person and the government and among the organ of the state. That means it is that type of law which is applied, which is applicable among person and government and among the organ of the state. That means uh, it is also applied to the organs, very familiar organs: executive, judiciary, and legislature. The constitutional law is accepted as the national law. National law means different nations have different type of constitutional law. So depending on the nations, the law of the constitutional law of that nations may differ. It is also called local law because it is applied inside the country as a fundamental law. Constitutional law, also called local law, because it is applied within the territory of the country, within the border of the country, or within the area of the certain country. For example, Nepalese constitutional law applied within the territory of Nepal, Indian constitutional law applied within the territory of India, and similarly, Chinese constitutional law applied within the territory or area of the China. Clear? The constitutional law determines the structure of the government and its power as well as its application. Similar with the constitution, how the constitutional law determines the structure of the government. What type of government may exist in the country, that is tells by the constitutional law. For example, in Nepal, there are three layers of the government: federal government, state government, local government. So how that type of government is formed, and that also prescribed by the constitutional law, and how much powers to give exercise this government as well as its application. Application means how is it applied, how laws are applied, how government acts. These all things fall under the constitutional law. It arranges, means constitutional law arranges the functions and the relations of the organs which are established to govern the state. It arranges functions, powers, methods, techniques among the organs of the state. Organs, what type of organs? To govern the state. Numbers of organs of the government to govern the state, and the balance or relations maintained by the constitutional law. So, it is known as the main part of the jurisprudence which interprets the constitution and prescribes the rights, duty, function of the constitutional organs. It is also main part of the jurisprudence. Jurisprudence, very common word, knowledge of law, skill of law, which is studied as jurisprudence. And in the jurisprudence, constitutional law is very important. And constitutional law in jurisprudence, why is it necessary? Because it interprets the constitution, rights, duties, and functions of the constitutional organ. Then what is the constitutional law? In bullet wise, look at here. It is the fundamental law of the state. It is the main law of the state. It is the backbone law of the state. State means of the country. Clear? It is the major law of the country. Without it, the country cannot exist or cannot run. Similarly, it does not relate to private law. Private law, family related matters law, and law, divorce, marriage. These things fall under the private law, but constitutional law never relate with the private law. It is public law. It applies the public official, or it is applied to the governmental official or organ of the official. That is, it is public law. It is applied between the person and governmental organs. So, relations of the persons and governmental organs, administrative type of law. So, it is quite similar with the administrative type of law. So, it is applied between the person and governmental organs. It is the law to determine the limitation of the governmental structure, power, and exercise. Obviously, constitutional law also prescribe the structure of the government, what type of government may exist in the country, how the governmental organs exercise their power, duties. So these things are also fall under the topic or fall under the constitutional law. It is the main part of the jurisprudence because we found numbers of definitions, numbers of principles, numbers of facts in the constitutional law. So look at here. The Constitution determines the rights and duties of the ruled class and guides the government to rule. The ruler class always wants to rule by gaining maximum rights. Ruler, the ruler, that means leader, wants always rule the nation by gaining, by exercising, by securing maximum rights. And the ruled class means general people wants to utilize the more facility, freedom, or fundamental rights. The Constitution, which is the fundamental law of the country, determines the state governing system of that nation. The Constitution separates the jurisdiction of executive, legislative, and the judiciary, the three organs of the state, and limit them to their jurisdiction. Constitution, first of all, clearly prescribe the jurisdiction of executive, jurisdiction of legislative, jurisdiction of the judiciary. That means executive how to law implement, legislative what type of laws are made, how laws are made, and judiciary how laws are implemented or how laws are explained or how laws are interpreted. These techniques or these ways are prescribed by the Constitution. And not only these, but also Constitution limit them. That means they means organ of the government to their jurisdiction. Similarly, no conservation of the people's right is imagined without the Constitution. No protection of people's right is imagined without the Constitution. Conservation means protection. The Constitution is necessary to all of states, whether they are democratic, absolute, rich, poor, big, small. Whatever the country may big, may small, may absolute, may democrat, may monarch, each and every type of country, each and every type of the nation need the Constitution. Then, what is the difference between constitutional law and Constitution? Very closely we look at here, Constitution and constitutional law seems to be quite similar, but on certain grounds they are different. Note that the term constitutional law is much extensive, much bigger in nature with its concept that the term constitution. Look at here, constitutional law extensive in the nature with its concept than the term constitution. How is it extensive? How is it bigger than the constitutional? How its scope is bigger than the constitution? Look at here. The constitutional law includes the constitution. Constitutional law includes first constitution, next judicial precedents. Judicial precedents, important precedent, landmark decisions of the Supreme Court called as a precedent, and that judicial precedents is also includes the constitutional law. Relevant statutory law, not only precedent. Relevant means related statutory laws are also fall under the constitutional law. And convention, international convention, which govern the nation's constitution also. So these four things compose the constitutional law. or comprises the constitutional law. It has been developed by the interpretation of the Constitution through the judicial review. How constitutional law is developed, how constitutional law is emerged, how constitutional law is made. Very simple. It has been also developed or originated or created by the interpretation of the Constitution through the judicial review. Judicial review, judicial activism, judicial decisions. Clear? The constitutional law of the country comprises of different legal and non-legal norms. Very clear. Legal norms. The legal norms are those which can be enforced and applied by the courts, whereas non-legal norms refers to conventions, usage, practices, customs. Legal norms and non-legal norms combinedly forms the constitutional law. Legal norms are those norms which is applied by the courts, which is implemented by the courts, which is administered by the courts, and non-legal norms are not applied or enforced by the courts. But these have also certain norms. These have also legal powers. Why? Because non-legal norms non-legal norms refers convention, usage, practices, and customs. This much. Thank you.